Okay, this may be a little bit of a review for some of you who've been through the patent process. I put this up just as sort of a demonstration that there's often a lot more that meets the eye when you see a particular product. Here you have just a typical razor, a multi-blade razor, and yet every single one of those lines that you can see that you may not be able to read is a patent. There's a patent on particular features of the razor, from the blades, the ejection mechanism, the way to put the blades back onto the razor, the design of the handle, the design of the packaging. And just to kind of get you thinking that there's often a lot more that you can patent on a particular idea that you may have. So what I'm going to talk about now could be a bit of a review for a lot of you who have been through the patent process. It could be helpful for those of you who haven't. Sort of the basics, some of the requirements of what you're going to need to include on a patent, what you're going to need to look out for as far as previous inventions, what's called prior art, and particular processes that you may go through in the patent office, and examples like the length of time that it would take to get a patent. Again, this is your typical lawyer's disclaimer. This is for information only and not legal advice. Okay, so here we have, what is a patent? A patent is a property right granted to an inventor by the government that gives a patent holder the right to exclude others from making, using, selling, offering to sell, or importing an invention into the country where the patent is issued. And sort of a peculiar definition for something. It's not a right to do something. A patent is not a right to practice an invention that you have. It's a property right to exclude others from doing what you've come up with. So it's not an affirmative right, it's a right to exclude. And just to point out the difference between a patent and, say, a trademark, a patent gives you a monopoly on an idea that you've come up with, and in exchange for that monopoly, you have to tell everybody what it is that you invented, how it works, what it incorporates, what it includes, so that other people could go practice the invention. Of course, they can't do that if you have your patent. They'll have to get a license or something from you, but it's an exchange, an increase in public knowledge in exchange for a monopoly for you. A trade secret, on the other hand, is something that you would just keep secret. You keep it secret for as long as you can. You don't tell anybody about it, and you can protect that as long as you can keep it secret. And once it's out, you lose it. You can think, for example, the recipe for Coca-Cola. I don't know how long they've kept it secret, but if it came out, you could not get a patent on it anymore. And just for those of you who aren't very familiar with patents, just the general look of a patent, there are some particular requirements that you have to have. This is a utility patent. You've got your inventor in the top left corner, patent number, and particular dates of interest, the date that the patent issued, the date that you would have filed your application for this patent, and then some particular requirements that you're going to need. The abstract you see here, the field of the invention, the general background of the invention, and prior art, just to kind of summarize what's come before your patent, a description of any drawings that you may have used for your patent, and then a written description which describes the way that you can use your patent, what it incorporates, the features, different embodiments of your invention, and then most importantly, to end it, the claims. And the claims will describe the scope of your invention and also any limitations to your invention. That's what's really important. It outlines your invention, what your protections are. And those, obviously, you should try to write or have your patent attorney write the broadest claim you have to protect your invention, and also as many variations on it as you can get. So just to highlight a few of the important things about patents, what is it? It protects the technology and helps maintain an edge by providing a sort of barrier to entry for potential competitors. If somebody has an idea, they see that it's patented or something very similar is patented, they may be less likely to enter whatever field it is that you have your patent on. They may be more likely to license your patent. There is a strength when you have a patent. It gets you a little bit of leverage in negotiation. For example, say you have a patent on some feature of cell phone technology, say you're Samsung or something, and another company or person has a patent on a different feature. You can cross-license those patents so that you have access to their patented technology, they have access to yours. You can both benefit from using this technology without having to worry about litigation or getting in each other's way or any potential infringement on either side. There's also a defensive strength. If you have a patent, even if you're not using it, remember it gives you the power to prevent other people from using it. So if you have a patent, you can prevent other competitors from entering your realm, whatever field it is, simply by saying no. No, I'm sorry, I'm not going to give you the rights to this. I could potentially sue you. And again, it's great for revenue generation if you can manage to commercialize your invention. You can license it. You can, if you're an inventor who's not particularly interested in marketing, developing, and selling your invention, you can assign the rights to your invention to a company who will do that for you in exchange, for example, a royalty. And of course, there are some entities who will collect patents and sue whoever it is they can and generate revenue that way. And again, just to highlight that misconception, it is not a right to practice. Your patent is not a right to do a particular thing. It's a way to prevent others from doing a particular thing. So what can be patented? Just about anything. Whoever invents or discovers any new or useful process, machine, manufacture, or composition of matter, or any new or useful improvement thereof, may obtain a patent. And this includes just about anything you can think of except for this little list of exceptions here. A law of nature, for example, E equals mc squared. That just is. A product of nature, a natural occurring gene, for example, human gene. Physical phenomena, abstract ideas, human organisms, and mental processes. And by mental processes, I mean something, for example, the method of thinking about something happy until you feel better. You're not going to get a patent on that. Yeah. So a few different types of patents, and most of the ones that I think we're going to be concerned about are utility patents. There are design patents, the particular design of, for example, somebody was talking about a pen earlier. You can't patent a pen, but if you have a very cool looking pen, you can protect that design for it. You won't get any protection as far as the functionality, but you will for the design. A plant patent, probably not too applicable for most people. Utility patents being inventions, mechanisms, things that do things. There are different types of applications too for utility patents. You can get a provisional application, which is sometimes a good idea, sometimes not. I won't get into the specifics, but what it really is a general outline of your invention that has quite a bit of detail, but not everything you would need to file your actual patent. And what it really does is gives you a place. It establishes your priority. So if you have enough to go on that you want to get your place in line so that nobody can come after you and steal your invention or claim priority before what you came up with, you may want to consider a provisional application. It's not examined by the USPTO. It really is just a placeholder, and it gives you a year from that date to file a full patent application. Non-provisional applications, these are the normal USPTO applications. And then there are certain applications that you may have to file in addition to these. These are continuations where you have the same written description describing your invention, but you may want to add claims, claims being different embodiments of your invention, different things that you want to claim. Divisional applications where for a patent application you can only have one inventive concept. You can claim particular embodiments of this inventive concept, but you can only have one. If an examiner thinks that you have more than one, or if you think you have more than one, you may need to file a divisional application, which it's the same specification, it's the same general idea, you're just adding a different invention to it. And then you have continuations in part, where you would add new subject matter and new claims about this new subject matter at a later date than your original application. Your original application will have that priority date of the original application. Everything new will have the priority date of the date that you introduced it. So how long are these patents? It's 20 years from the earliest filing date. And this earliest filing date is the date of the earliest non-provisional application. Now, if you do file a provisional application, you can get up to 21 years. If you remember, I said for a provisional application, it gives you 1 year to file an actual application. If you waited till the end of that 1 year period and filed your application and got your 20 years from that date, you would end up effectively with 21 years of protection. Adjustments may apply. For all of those who have been through the patenting process, you probably know that it's not a very straightforward and quick process at all. There are many different actions that go from the examiner back to you. You can make amendments to your claims. They can reject what you've come up with. You'll have to overcome those objections. There can be administrative delays. And depending on what has occurred in your prosecution, the office may end up giving you some time back, giving you some credit back, because these things can take years from the time that you conceive the invention, reduce it to practice, file your application, and then actually have a patent issued. That can be many, many years. And that 20 years starts well before your patent will be issued. So they may credit you with time back if it's been a long time. So who is the inventor? Inventorship requires an individual has made a specifically identifiable contribution to the conception of patentable elements of the invention. And individual is a highlight here. It has to be a person. An inventor is a person, even if that inventor assigns the rights to the invention to, say, a company, for example. So what does it mean, conception? Conception requires a definite and permanent understanding of the invention as it will be used in practice. And what does that mean? It means for me to have conceived an invention, I will have to be able to communicate that invention to somebody who has some kind of experience in that art, and they will know what I said. They will be able to practice my invention from what I have told them. It can't just be an idea. For example, I have an idea for an automobile that flies through the sky, for an airplane. You would have to describe the engines, the wings, the structure, and actually be able to allow it to take place. And reduction into practice, this can be achieved in two different ways. You can create a prototype that works, that embodies your invention, or you can file an application that describes your invention in full, how it works, different embodiments, what it incorporates, what it's made out of, etc. Reduction to practice, though, is not enough just to be an inventor. For example, you see, if you give your design to an engineer to build, the engineer built it, the engineer reduced that invention to practice, they're not an inventor. So the date of the invention is currently considered to be the first date on which conception was completed. There is an exception to this. If you conceive of an invention, but then don't do any work to reduce it to practice, then you will not get the benefit of that conception date. It will have to be, you would have to have worked diligently from conception to reduction. That time when you first started to work towards that reduction to practice is when you'll get that date. Each inventor, if you have a team of inventors, will have full rights to that invention. However, many of you may know this, many of you may not. Patent laws can undergo quite a bit of changes. It already is in the process of undergoing changes with something called the America Invents Act. The United States is switching from a first to invent country to a first to file country. So the date that you have invented your invention is not quite as important anymore. It's going to switch to who filed first, and that file date is going to mean the difference between your patent and not. So, yeah.
It's March 2013.
Some of them have gone into effect. Some of them will in September. Oh, right, right. Yeah. The provisions there, the American Invents Act is quite long, and there are a whole lot of provisions in there. Some of the effective date for these provisions are staggered, but it'll be March of 2013 for that. And actually, when I'm finished with the brief overview of just the typical features of a patent and what's required and some of the processes and things that you may come across in a patent office, Ron is going to pick up with the American Invents Act and sort of give you a sort of a navigation guide, a survival guide to the American Invents Act. Okay, so what is required? Usefulness. The invention must have a useful effect or purpose. And don't read too much into this. Bare utility is enough. It can be the most minor useful invention that you can think of. This really is not much of a standard at all. Novelty. This is important, though. Obviously, an invention must be new. You cannot patent somebody's old invention or an invention that's well known. And non-obviousness. You cannot change a previous invention in a minor way and then claim that you have something new if it would have been obvious at the time. For example, if I invent a medical screw that has a squared top, the shaft of the screw with the spiral metal around it, you could not then say, well, I've come up with another screw that has an octagon-shaped head. It's probably obvious. It's probably obvious that that could have had different shapes for different screws.
But they still did the razor.
What's that?
They still did the razor.
They still did do the razor. You're going to have to do quite a bit of arguing just to make sure that you can demonstrate that it's not obvious, that it does have different purposes or uses for like a single blade versus a double or a quadruple blade or...
So
go ahead.
Pharmaceutical patents fall under this too? They can't reprint a study and then reword it and print it in another journal? That is a completely different study?
Pharmaceuticals are a little bit different in that there's an exception for those. It's called new use. If you discover a new use for a previously existing pharmaceutical, you can get a patent on that. Yeah.
That would be a use patent.
Right.
The compound.
Right. Yes. Enablement, this essentially means that you have to have enabled somebody in the art to practice your invention in your disclosure. Your written description is the specification that I mentioned earlier, just describing different embodiments to your invention, how it works, the materials used, temperature ranges, anything like that that you can think of. Anything that would specifically allow somebody to practice your invention. And best mode, how you think your invention is best put to use. Okay, in prosecution, what will happen when you file your application, it'll get assigned to an examiner. And the examiner will be in a particular division of the USPTO, somebody with experience in that field, somebody who, for example, if it's a computer chip patent, will have an engineering background, electrical engineering or computer science perhaps. Office actions and responses. This is what can take quite a bit of time. You submit your application. The examiner will look over it first for formalities to make sure that it complies with every rule that it could. It has the correct format, the correct usage, the counts and particulars for written description, whatever it may be. Then they'll send it back to you if there are any issues you need to fix, and then they'll start to go to the substantive composition of your patent application. And it could be that your claims are rejected in light of prior art or combinations of prior art, and you may have to amend them, or you may have to cancel particular claims or add different ones, have different ways to describe it. But this can be quite a bit of time. They may ask you to draft divisional applications or maybe continuations. But the current average right now is 33.7 months, about 3 years. The goal is about 20 months by 2015. I don't know how realistic that is, I haven't heard of anybody, at least in the United States, getting a patent that quickly. I'm sure it can happen. In other countries, it's not uncommon to get a patent within a year. But for some reason, in the United States, it can take, I've seen them take 10 years.
So what countries do we file? What countries do we file?
What's that? UK? There are different requirements in other countries, too. They have different novelty requirements. It has to be more than just barely new, but absolutely new. So there's not as much prior art comparisons, at least some of the time, in different countries.
That's the one I mentioned to you is getting issued on Tuesday. That's been 6 years. And the one that's behind it is 8 years.
Yes, so it's definitely a process, and it can definitely be an expensive process. What's that? Okay. So foreign prosecution patents are issued by a country. And if you want patent protection in a particular country, you should seek a patent in each of those countries. Although there is a procedure that I won't get into where you can basically designate a handful of countries that you want protection in. There are some statutory bars that can trigger. This is called USC 102. This is the novelty requirement of the patent. Essentially, it says what we've already said. You cannot offer a patent for sale or the invention for sale. If you do, you have a year to file your application or you'll be barred. If your invention has been disclosed in any patent or publication in this or any foreign country, you will be barred from obtaining your patent. And this changes a little bit with the AIA, which I'm sure you'll get to. Some activities may not qualify as public disclosure if you do them under a confidentiality agreement. Perhaps you need help developing your invention or creating a prototype. And just to touch a little bit on some of the AIA prior arts, it's now that anywhere in the world before an effective filing date, if something is patented, printed in public use, on sale or otherwise available, you will be barred. It used to be that the public use and on-sale bars were for the United States only, but that's going to change. This PCT application, what I just mentioned, I'm not going to describe that too much because that's an application that you can file to get protection in a number of countries if you follow certain procedures after that. There are some exceptions, a grace period disclosure, which is not quite the exception that it seems to be, which Ron's going to talk about a little bit. And, of course, joint research agreements. And I'm going to leave it there because that's sort of the general introduction